What you missed on the previous episode of Plugged In with Seeff
You marry
Properties.
in community of property, 50% of his or her liabilities are also become yours.
So I couldn't buy a house on my own without my husband knowing, for example.
So remember, generally, when it comes to real estate, the banks have got a mortgage bond over your property.
Can you pick anybody to execute, like when the passing does happen? Can it be anyone who actually executes the will?
Yeah. So anybody can be an executor.
Okay.
You know, usually a lot of people will select family members or friends, close friends, or even professionals. The main thing with selection of an executor is that you must know that that person will follow your wishes. Because remember, he's answerable to the master, he's answerable to the beneficiaries.
Yes.
But if his intentions are not good, he can abuse his position and, misuse the assets. Say, for example, if there's cash in the estate, he can squander that money and getting it back would be a problem. So it's always wise to choose a responsible and good executor. And 9 out of 10 times, it's best to always choose an executor who's not a beneficiary under the will.
And so what happens if, say, maybe, this person chooses somebody, a cousin or a distant relative, and the beneficiaries say, no, but we don't want this guy to be our mother's executor or whatever. Can you change him? Can we apply to the courts?
They can apply, yes, they can apply to the courts to change. But they'll have to give reasons. They can't just say because we don't like him.
Okay.
They'll have to tell the master that no, he's maybe in breach of his responsibilities, or he's, under the will, or there's a problem in terms of why they don't want him as an executor. Because remember, the appointment of the executor is also the wish of the deceased, of the person who passed away. Yes. It was his wish that this person must be, and there must be a reason as to why he selected him as an executor. Yes. So the beneficiaries, sometimes the beneficiaries will also have this thing of saying, this executor is too strict.
Yeah.
And he doesn't want to give us the money that our parents have left behind, and we want to buy a car, we want to do this, we want to go on holiday, and the executor is just refusing and saying, no, your parents would have never agreed to this. So that is the reason why, the wishes must be followed. Unless there's justified reasons why you want to remove the executor.
You mentioned the point earlier about working with Real Estate Institute of Botswana and Real Estate Advisory Council registered estate agents.
Yeah.
What are the benefits to you, the conveyancers, really, to work with these agents, as opposed to just anybody?
So generally, I'll be very clear that a transaction that's structured by the parties without the involvement of a reputable registered agent, for us, it becomes like we find ourselves now doing the jobs of the agent. Meaning, the agent advises the parties so well that when it comes to issues of the structure of the agreement, when the payment of the purchase price is going to be paid, how it's going to be secured, handover of the property, the condition of the property, you'll find that the transaction runs extremely smooth. Whereas when we deal with transactions that are structured by the parties themselves, you'll find that when it comes now to the transfer and it's registered, and now we are holding the money in trust, and then there's a big fight that will start. You'll find that no, the seller was supposed to have fixed up my toilet. Don't release 2 million pula because one toilet is not fixed. Yeah. So there's petty issues that ruin the transaction at the end of the day. And I always tell people, I always say to them that some people, for them, it's their first experience to buy a house. Yeah. And if you go through the proper channels and you do spend the money and the time to acquire the property, your experience will be nice. You'll enjoy your asset.
Yes.
Now, you can imagine if it's your first house and you're going through a miserable time where you've now received the house and, your window frames are falling out, and there's so many defects around the house. And now, you're basically saying that, my acquisition is a waste of money. I have to spend so much money in fixing it. So the money that you saved by going directly now is being spent on trying to rectify what would have been picked up by experienced people at the beginning. And, we always say as conveyancers and as attorneys, we always say that we don't get involved in the inspection of the building. That's not our job. I don't go to the property and look at the property and say, okay, what is part of the sale? And if I'm going to go, I'm going to charge my hourly rate to go inspect that property. But I don't do that because it's not part of our mandate. It's not part of our services because we're supposed to have both parties' interests.
And you were talking about how there are some aspects of the sale agreement that you actually you can't vouch for. For example, what the property comes with, the state in which the property is, and things like that. So this helps, having a registered agent helps in kind of bringing all the terms of the sale together. Am I understanding you correctly?
Yeah. So what happens when you have an estate agent and you have an experienced estate agent? They wouldn't list a property because their reputation is also on the line. So they wouldn't list a defective property. So any property that they take on, they would do their own inspections and they would, describe the condition and the status of the property. So you'd find that when we work with estate agents in terms of our sale transactions and property transfers, once a transfer is done, the transition from the seller to the buyer is very smooth. However, when you'll find that there's been times, I've been doing this for now over 15 years. There's been times where the parties try and bypass the agent because they want to save on maybe the estate agent's fees. And then majority, I would say a lot of the times, you'll find that the purchaser ends up now with a property that is defective. Maybe there's a huge outstanding water bill. You can't get his water connected. You can't get his power connected. There's so many defects in the property that when you end up seeing what he has spent in terms of legal fees to sort out those problems, in terms of money on contractors, because now he or she is also under pressure from the family to say, we're moving into our new house, and when are we going to move in? So it's a really painful experience when they do find that especially a buyer who's got no experience buys a property without understanding what they're buying and without doing the proper due diligence and checks which the agents do. You'll find that there's always disputes that end up happening, or arising, yes. And my job then, our job as conveyancers or attorneys now, we put in very difficult positions. So the one thing that you need to also understand is that usually the sale agreement does not stipulate that the purchase price will be withheld until proper handover is done. So when ownership transfers, according to the law, the seller is entitled to his money. Whether the house collapses the next day, that's not the seller's problem. So the seller is entitled to his money. So 9 out of 10 times you'll always have the buyer saying, no, don't release the money. I'm not going to sign your statement of account. I'm not going to sign. I don't want the money to be released because there's 20 or 30 problems with the property. And then, we obviously caught up in terms of a balancing act of whose interest we should protect. We do try, you do try and assist, but 9 out of 10 times you have no option. You have to release the purchase price. And now the purchaser will then, we usually refer the purchaser to our litigation department. And then you'll find that now the purchaser is spending money on litigation and for the next 1 or 2 years fighting with the seller for damages that the purchaser has sustained as a result of not getting proper and good advice in terms of his or her acquisition.
And generally, is there some kind of recourse for that? Is there something that can be done in terms of the purchaser?
It's essentially it's on how well crafted your sale agreement is.
Okay.
Because all of those things would be catered for in the sale agreement. And if there's failure by the seller to deliver in terms of the sale agreement, then then it's breach, and then the usual breach remedies will follow.
Okay.
And you can obviously only exercise your rights in Botswana through the courts.
Okay. And say now, Akheel, if in the sale agreement the two parties have agreed that the seller would vacate the property, say now at the end of August, right, the 31st of August, and then from the 1st of September, the purchaser would be able to occupy. And for some reason, at the deeds registry or at BURS, the process takes a long time, and it doesn't, or maybe the transaction happens before those dates. Does the seller now pay rent to the purchaser, or what happens in that situation?
Okay. So, firstly, there's certain things within people's control, and there's certain things that are not within people's control. So processes at BRS and at deeds registry, as much as when we promise turnaround times, turnaround times are based on the normal turnaround times, and also it's based on what from our experience.
Right.
But no one can guarantee you turnaround times.
Right.
So what happens is that if the agreement, if the occupation is to be given prior to registration, or the occupation date arrives and registration hasn't taken place, and that's an unforeseen or unpredictable circumstance under the agreement, because usually some agreements are supposed to cater for that.
Yes.
The general rule is that if you don't give me my purchase price, I don't have a problem. Use my property, but pay me occupational rent until I get my purchase price.
Yeah.
Because, then you'd find that purchasers will be upset to say, no, but I've got the loan, the money is there, why should I pay rent? Because it's not my fault that the transaction is delayed. But it's not the seller's fault as well.
Yeah.
So the rule is that you're benefiting from the occupation. Yes. That's the reason why you're paying occupational interest, because you are living in the house. The seller has not received the benefit of the purchase price. So sometimes you'd find that the parties, if there's mutual trust between the parties, they'll enter into what we call an addendum. It's an agreement to vary the arrangement, where if it's a cash purchaser, the purchaser will say, you know what, it's already at the deeds office. I'm happy to release the purchase price, give me occupation, and then you just wait for the registration process. But obviously there's a huge risk with that. And parties often do that. We don't advise on that, but they, at the end of the day, if they're willing to take the risk, then it's generally we have to advise them on the risks, and if they're still willing to do that, then we do the addendum. But the rule is, if you're going to take occupation and you haven't paid for what you're occupying, then you must pay occupational rent.
Yeah.